Okay, so let's hear it.
Okay. Yes, sir. Let me go ahead and push play.
Right to every story, and you should never judge a person based on one version of the story. That no matter how thin you roll a piece of paper, there's two sides to the paper. So I'm going to tell you what I have so far on the side of the story that is not in your favor. And then give you an opportunity to fill in the gaps, correct any misinformation you think we may have, and tell your side of the story. Because this will be tonight your first, last, and only chance to give us your side of the story. Because beyond here, how do you know how it works? Attorneys get involved, and then attorneys tell you not to talk. And
that's why I'm trying to talk to you.
Yep. So,
well, because, man, that's the thing is, man, I ain't got nothing to hide. That's why, man, otherwise it would have been like, man, if I thought I needed an attorney, I would have been like, look, I need a lawyer. You know what I mean? But I know I haven't done anything, you know, so anyway, give me your side.
I'm going to let you know a couple of things. Detective picture is absolutely accurate with the timestamp on the video. We have you on video walking on 2nd Street from where you live toward Wrongfully, which is the road that the treehouse is on. 8:11 p.m. At 8:15 p.m., the first call comes into 911 telling our dispatchers that a guy has been stabbed, he's dead, and he's laying face down in a pool of blood. Just hear me out. So you have 4 minutes from where you're at to where this thing happens. Now, the really disconcerting part of all of this is at 8:19, 4 minutes after we have a report of a man being killed, we have you and Rory on video walking back from the treehouse toward...
That's got to be impossible, though. Because, okay, you know, like I said, man, I wish I could try this here, because, man, again, man, go back and check the times on video. Because that had to be somewhere around the same time. Had to. You know what I'm saying? Because, man, you know, I remember, the whole thing with the police lights and stuff like that. It was not long after we went and got cigarettes. So, man, how could I be, Tom's on buying cigarettes while I'm supposed to be over there at the CVS? You know what I'm saying? Now, I do, like I told him, I have a vague memory of, walking through the drive-through at the CVS.
Okay.
You know, so, man, I may have gone there earlier, I could see that, you know, but I would know I didn't go there later. I know I didn't go there later, but, I may have gone there earlier. But, literally check the video,
Okay. Now, I'm going to tell you some other things that Detective Picture hasn't shared with you that I'm going to share with you. That's on our side of the story. In the walk from Laurel Avenue on 2nd Street to where you live, we found in lot 72 a knife. Okay, on that knife is blood, and on the handle of that blood, latent DNA. That's going to the lab. Okay, and a little further up the road, in the back of a boat, parked alongside 2nd Street, is a mask. And the mask has very weird, freaky, scary face on it, but it's also made out of foam, and on the front of the mask are 3 blood smears. And the mask has a really nice elastic band that goes around the back of the head, and a nice foam pad in the front. It's loaded with DNA. Okay? Now, all that stuff's going to go to the lab.
Cool.
Okay?
I'm confident.
Okay.
Totally confident. You know?
And we have wounds on our victim that are consistent with the knife that was found in lot 72. So what
we're trying to listen to
know is that the story and the details of the story are not stacking up on your favor.
Well, I'm just saying, all that stuff that you just told me, test all you want.
Okay.
You're not going to find anything there for him, with anything mine on it. You know, granted, if the mask came from the house, man, it might have my fingerprint on it, man. Who knows? I may have touched it. Same thing with the knife, man. I may have touched it. But I guarantee you, man, you ain't got no DNA, man, for no man on the inside of that mask, and there's no man for him. I've never grabbed a knife and did anything to anybody. So, man, here now. So, I mean, the timestamp with the video, I mean, like I said, go check.
That's all.
Okay. So I'm trying to understand the exact nature of your Rory tennis motion.
Well, Your Honor, the blood, she tells me that
Now, what is it that you're asking me to do?
I would ask this, Your Honor. I mean, because again, to be fair, and like I said, to make sure that the jury has the right information, I would either ask that the video be allowed to be back with the deliberations, or that Your Honor, instruct the jury.
Okay, so I don't see a problem, but we'll hear what the state's...
But there is no inconsistency here. What we argued is genuine. We argued that he wouldn't know it's Matt Bonnet's blood on the knife. They simply identified the evidence that they have. He deduced that it was Matt Bonnet's blood and told Paul Belmonte. This video is not evidence. We haven't contradicted anything in evidence. We made argument. So I would submit to the court, there's nothing here to rule on other than nothing, really.
Your Honor, if I might. No, they said this was their single most compelling piece of evidence, that there was no way I could have known.
Okay, stop
And yes,
it. Get to the point that somehow or other they were misrepresenting the state of affairs because they knew that someone had told you that it was Matt Bonnet's blood and they intentionally misrepresented that? Is that what you're claiming?
Yes, I am saying that.
Well, that video doesn't establish that.
Your Honor, I definitely could infer from what she just told me that was Matthew Bonnet's blood. If it's consistent with the knife wounds, if again they have blood on the knife, then it only stands to reason that it's Matthew Bonnet's blood. Again, they're purporting that conversation to be something that is totally evident that I had to be there. And they said there was no possible way for me to know. Well, yes, there is.
Okay, thank you. I'm denying the motion. I find that the information conveyed to the defendant during the Penny Phelps interview is not inconsistent with the state's argument. There was mention of blood found. It was, in fact, I believe there was indication it was going to be sent for testing, but it was never told to you, oh, that's Matt Bonnet, that's Matt's blood. It was not. So anyway, Mr. Tucker, I've made my decision. I recollect that, no, sir, I'm not going to argue any further. I've heard your motion. I've made my decision. I allowed you to, when the state objected during closings, you're right, they can't use something as a sword and a shield. That didn't come in because of the interview, the statement, because it's a prior consistent statement, basically, that's inadmissible. But when they objected and you started to talk about this particular interview, I overruled the objection and said that you could mention that you were at the station for a long period of time and questioned about the event. So I allowed you to make some explanation. I didn't allow you to go into what was said. But yes, sir, you have.
I'm not trying to argue with you.
Well, that's what you're doing. If you had a question about my ruling, that's fine.
I do, Your Honor.
Okay.
I'm not trying to argue with
Wilson, what's your question?
Your Honor, yes, I know that Your Honor overruled their objection.
Right.
You did establish that I could talk about being at the station. I could not talk about what the hearsay would have been if what I was told. And I really do think, Your Honor, I mean, it is very, very, misleading to the jury to allow them to go back there and deliberate on something that could cost me my life based on, information that, again, they're not being provided the entire amount of information concerning what the major part of their case is.
Okay. I understand your position. I've denied the Ori Tennis motion for finding no violation, allowed the video to be played in the record, allowed the Ori Tennis motion, heard substantial argument, made a decision, provided rationale to support the decision. Understand you disagree with it. Understand you've preserved the issue should it become necessary, but in any event.
I'll go ahead and take the video off of there, yeah.
Okay. I don't mind. I saw Kerry in here. Did he want to come in here? Or could we ask Deputy Riccio if Riccio's there? Because I saw Kerry and there was some question about the operation. I saw him come in here earlier. I assume he wanted to check something.
He's going to turn the internet off on the TV so we can go back there for the access.
It's unbelievable. The AC has to be malfunctioning. It's unbelievable. I don't know. I'm gonna go check with court administration while Kerry's doing this. I'll be right back. This person's good.
But they have a different name than on the docket. So.
I imagine we'll be around.
Okay.
Okay, do we have all the jurors present?
Your Honor, the only remaining, I guess, issue is the unbolded
Oh,
3.10. It's really up to the defendant and the court. I just did it in.
well, it's fine. It's with me. We mentioned the.
No, as long as it's the same
Yeah,
document.
it's the same one here. Same documents.
Which number is it?
3.10, Your Honor.
Yes.
And what's copied yesterday, it was bolded. I just simply unbolded it.
Well, this is the one I have.
Same package.
Yes, I don't need a whole new package. I already got this one completely organized. I think. Well, let me look.
Should be same.
That's
Oh, sorry,
that's
Judge.
a different instruction.
Handed up the wrong.
0.10.
I apologize.
Okay, that is in lighter type, consistent with the type of the other instructions, so I'll substitute the one that's darker for the one that's lighter. It says the same thing. Thank you. Let's bring the jury in, please. Thank you. Please be seated, everyone. Good morning. Good to see you all here again this morning, members of the jury. So, yesterday you heard closing arguments. And I told you that in light of the hour and the like, that it seemed to me to make more sense to send you home for the evening, to take care of the business that we needed to take care of, and to have you come back this morning so you could receive jury instructions and have ample time for your deliberations. And so here we are to do that. So I'm going to now instruct you on the law applicable to the case. I'm going to use this packet of written instructions, basically verbatim. When you go back to deliberate, along with the evidence, you're going to have this packet of instructions, exactly what I'm using to instruct you. So you'll have both the verbal instructions and the written package. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Franklin Tyrone Tucker has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Franklin Tyrone Tucker, the defendant in this case, has been accused of the crime of first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, number one, the defendant intended the crime to occur, and number two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree felony murder and second-degree murder, it is not necessary for the state to prove the defendant intended the death of Matthew Reed Bonnet. It is not necessary for a principal to know every detail of how a first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery will be committed, as long as the principal intended the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur, and did some act or said something that was intended to help and did help the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur. To be found guilty of a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery, as a principal, it is not necessary for the state to prove a defendant knew another participant of the first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery while armed. Franklin Tyrone Tucker is accused of first-degree felony murder in count 1 of the indictment. First-degree murder includes the lesser crimes of second-degree murder, manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Reed Bonnet was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree felony murder or second-degree murder, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and in misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Franklin Tyrone Tucker may be found guilty of first-degree felony murder or any lesser included crime. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Matthew Reed Bonnet is dead. Number two, while engaged in the commission of a robbery, Franklin Tyrone Tucker caused the death of Matthew Reed Bonnet. Number three, Tyrone Tucker was the person who actually killed Matthew Reed Bonnet, or Matthew Reed Bonnet was killed by a person other than Franklin Tyrone Tucker, but both Franklin Tyrone Tucker and the person who killed Matthew Reed Bonnet were principals in the commission of robbery. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. Number one, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number two, force, violence, assault, or putting in fear was used in the course of the taking. Number three, the property taken was of some value. And number four, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim, when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist in any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that the knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. Counts 1 and 2 are linked in that the crime charged in count 2, robbery, is an essential element of the crime charged in count 1 of the indictment, first-degree felony murder. You should first consider the evidence applicable to count 2. If you find the crime in count 2 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. If, on the other hand, you find that the crime charged in count 2 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1. A guilty verdict on count 2 does not require a guilty verdict on count 1. You should find the defendant guilty on count 1 only if you find all the elements of that crime, including the essential elements contained in count 2, were proven beyond a reasonable doubt. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of first-degree felony murder is second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Matthew Reed Bonnet is dead. Number 2, the death was caused by the criminal act of Franklin Tyrone Tucker. Number 3, there was an unlawful killing of Matthew Reed Bonnet by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number 2, is done from ill will, hatred, spite, or an evil intent, and number 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Excuse me. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number 2, force, violence, assault, or putting in fear was used in the course of the taking. Number 3, the property taken was of some value, and number 4, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear. An actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if in the course of committing the robbery the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. If you find that Franklin Tyrone Tucker committed robbery, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried a knife, you should find him guilty of robbery with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Franklin Tyrone Tucker committed robbery, but you are not convinced beyond a reasonable doubt that he personally carried a weapon, then you should find him guilty only of robbery. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. Number 1, Franklin Tyrone Tucker intentionally and unlawfully threatened, either by word or act, to do violence to Roger Allen Roggett. At the time, Franklin Tyrone Tucker appeared to have the ability to carry out the threat. Number 3, the act of Franklin Tyrone Tucker created in the mind of Roger Allen Roggett a well-founded fear that violence was about to take place. And number 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Roger Allen Roggett may be found to have been in fear. An actual fear on the part of Roger Allen Roggett need not be shown. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Franklin Tyrone Tucker actually and intentionally touched or struck Roger Allen Roggett against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. If you find that Franklin Tyrone Tucker committed crimes charged, you also find beyond a reasonable doubt that Franklin Tyrone Tucker was personally wearing a hood, mask, or other device that concealed his identity, you should find Franklin Tyrone Tucker guilty of crimes charged while wearing a device that concealed his identity. If you find that Franklin Tyrone Tucker committed the crimes charged, but you are not convinced beyond a reasonable doubt that he personally wore a hood, mask, or other device that concealed his identity, then you should find the defendant guilty only of the crimes charged. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment and information for each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged with committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to say and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. As I explained, the evidence goes back, the written instructions go back, and these verdict forms go back. And I'm going to go over them verbatim right now as part of my instructions. They're not complicated. You should find them quite self-explanatory, but again, to be thorough, I'm going to take a moment here to review them. There's 4 separate verdict forms appropriately labeled to correspond with each of the 4 counts. So I'm going to start with verdict count 1, and you can see in big bold letters, there it is, identified as verdict form for count 1. In the upper left corner is the date line. When the jury has reached its verdict, the foreperson should put today's date, that's when you reach your verdict, which is January 25th, 2024. Right below the date line is the jurisdictional statement in the Circuit Court of the 16th Judicial Circuit in and for Monroe County, Florida Criminal Division. You will remember way back to jury qualifications, and we talked about everybody being a resident of the 16th Circuit, because in order to be a juror, you got to reside in the jurisdiction wherein the crimes were allegedly occurred and where the trial is taking place. So this tells us what the jurisdiction is. And then right below the jurisdictional information on the left is this, what we call the style of the case. State of Florida Plaintiff versus Franklin Tyrone Tucker Defendant, case number 2017 CF 841 CK. You've heard me say that multiple times. That's the case style and the case number. And below that is the heading of the form, and then there's 3 choices here. If the jury's verdict is we, the jury, find the defendant guilty as charged in the indictment of the offense of first-degree felony murder, the foreperson puts a check mark in the line ahead of that verdict, and then you see down here in the lower right is an area that says, so say we all, a line, foreperson. That's where your foreperson signs and then dates the verdict form. If the jury's verdict as to count 1 is we, the jury, find the defendant guilty of a lesser included offense of second-degree murder, well, then the check mark goes on that line. And then once again, signed and dated by your foreperson. And as to count 1, if the jury's verdict is we, the jury, find the defendant not guilty, then the check mark goes on that line and once again, signed and dated in the appropriate place. We've got a separate verdict form for count 2. This one's 2 pages. It's the same format, and I'm not, it's got the same information above the heading, and again, it's verdict count 2. So, if as to count 2, the jury's verdict is we, the jury, find the defendant guilty as charged in information of the offense of robbery, then the line ahead of that verdict is checked, and then the jury considers the questions or interrogatories if it's guilty as to robbery. Obviously, if you don't find the defendant guilty of robbery, you don't go to these questions, but I'm going through the form in chronological order, not by any means suggesting what your decision will be, but only explaining it as it's presented here. So we see some instructions. If you find the defendant guilty of robbery, you must then answer the following questions. First question, in the course of committing the robbery, was Franklin Tyrone Tucker in possession of a deadly weapon? One of two answers, yes or no. Whatever the answer is, if you get to that part, that's where the check mark goes. Yes in front of yes, no in front of no. And you go on to the next question. In the course of committing the robbery, was Franklin Tyrone Tucker in possession of a weapon? If you get to this interrogatory, once again, yes or no, lines ahead of both choices. Whatever the decision is of the jury, that's where the check mark is placed. And then the final interrogatory on the second page, in the course of committing the robbery, was Franklin Tyrone Tucker wearing a mask? Same choices, yes or no, check mark in front of that answer that the jury unanimously finds to be proven beyond a reasonable doubt. So, if the jury's verdict was guilty and as to robbery, and you get through all those interrogatories, then the foreperson, again, this time it's on the second page, but it's again in the right-hand bottom part, signs and dates the verdict form. Now, if the jury's verdict as to count 2 is we, the jury, find the defendant not guilty, so then there's where the check mark goes. You don't get those interrogatories, and you just have the foreperson sign and date the verdict form. That's count 2. Count 3, separate verdict form, so labeled. Same format at the upper portion. Again, heading clearly says count 3. And then we look at the choices that the jury, the decisions available to the jury. If it is, as to count 3, we, the jury, find the defendant guilty as charged in the information of aggravated assault, the offense of aggravated assault, that's where the check mark goes. And then you look at the instructions immediately below that finding, and you're told if you find the defendant guilty of aggravated assault, you must then answer the following questions. It's actually only one question. In the course of committing the aggravated assault, was Franklin Tyrone Tucker wearing a mask? Once again, there's yes or no options, lines in front of each one. If you get to this interrogatory, you check which one of those two options the foreperson does. The jury so finds, signs, dates the verdict form by the foreperson. As to count 3, if the jury verdict is we, the jury, find the defendant not guilty, then the check mark goes in front of that verdict and signed and dated by the foreperson. Separate verdict form for count 4, same heading, label, count 4. If as to count 4, the jury's verdict is we, the jury, find the defendant guilty as charged in the information of the offense of battery, that's where the check mark goes ahead of that verdict. And then following the instructions, if you find the defendant guilty of battery, you must then answer the following question. In the course of committing the battery, was Franklin Tyrone Tucker wearing a mask? Yes or no? Check the line in front of the answer that you find if you get to this interrogatory. As to count 4, if the jury's verdict is we, the jury, find the defendant not guilty, there's the line ahead of that verdict that's checked. And once again, when you complete the verdict decisions as to count 4, so say we all, signed by the foreperson, dated on the date. A separate crime is charged in each count of the indictment and information, and although they may have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged, except as explained in the instruction for legally interlocking counts. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. And I'm going to explain a little bit more about how we handle that provision here in the 16th Circuit in just a moment. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. And that includes this unit here. That's going to go back. Its operation is fairly straightforward, so if you care to view any of the video evidence, you'll be able to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So I'm going to ask attorneys to approach the bench. Can I see this a second, please? Remember back in jury selection when we talked about alternate jurors? And we heard from a couple of folks who served in alternate jurors, and I explained, I believe at that time, the importance of alternates and how I didn't relish by any means excusing alternate jurors because, as has been the case in this particular case, our alternates have been here throughout, just as attentive and patient and involved as the first 12. And now I have to excuse you because the first 12 jurors have been here throughout and are now ready to deliberate, and the law doesn't allow any more than 12. So one might ask, Well, why were we here, Judge? I mean, goodness gracious, we've listened all this time. We'd like to share our thoughts now that we've spent all this time here. We'd like to hear what the others think, and you're denying me the opportunity. I understand that feeling entirely. All I can tell you is that more often than not, in trials, especially one of this duration with this number of jurors, things happen where one or more of the first 12 are unable to complete the case. If we don't have an alternate to sit in that very seat that's been vacated, we have a mistrial. And you already heard instructions about how a mistrial is a waste of time and inconvenience on the cost and all the above. So we try to avoid that by having alternates. In this case, we haven't needed them, so with my sincere thanks, I'm going to excuse Ms. Van Stry and Mr. Amsterdam. But thank you very much. I certainly appreciate your service and your involvement. So just a couple other things. I'm going to give those folks a moment to clear the jury room. Just give a few further explanations about some of those instructions. I mentioned about electronic devices. You've heard lots of instructions about the prohibition about electronic devices, and it makes sense. In terms of the prohibition against having access to the electronic devices, the personal devices, that's an administrative order from the Florida Supreme Court. That's not something that yours truly has concocted on his own. That comes from the Florida Supreme Court, and of course we honor their authority and their rules and regulations. But here, instead of having you leave whatever devices are on the seats there, we have what's called a lock box in the jury room. So you bring them in there, bailiff will be in there at that time, present whatever electronic devices you may have. Right before your very eyes, they're placed in the lockbox, it's secured, there it sits. So I think that gives people a little bit more security and assurance that their devices aren't going to be compromised. Not that they would be, but just in terms of state of mind, they're right there, and when you're finished, they're there for you to repossess, to take again. So that's how we do that. You will be able to take your notepads with you now. If there is some question, problem, communication that you believe is needed with the court, then your foreperson should take a clean page, nothing with any kind of marks on it, but a clean page, and in legible, complete, comprehensible fashion, write or print whatever it is you want to ask me or tell me. Judge Jones. Then, when it's complete, the foreperson should put his or her name, fold it in half, knock on the door, give it to the bailiff. The bailiff will alert me, give it to me. I'll look at it. I'll share it with everyone, the lawyers, and I will do my best after receiving input from them to provide an appropriate answer. So, the alternate's gone. Ladies and gentlemen of the jury, you may now retire to consider your verdicts. Okay, so when Deputy Riccio comes out here after securing the electronic devices, I'm going to give him the verdict forms, the instructions. Then I'm going to have him, or one of the security officers, take all the evidence, bring it back, knock on the door, present it along with this device to view it. So what I would ask the clerk to assemble it, which you probably already have, but when I step down here, if Mr. Tucker and the state wants to examine the accumulation of evidence, just to be sure that it's complete before it goes back, that everything that's supposed to be there is there, and similarly, everything, if there's anything that's there that shouldn't be there, then it doesn't go back. I doubt if either one of those is the case, but just to be sure. Then, as we mentioned yesterday, you all don't have to stay here if you care not to, as long as there's a means to contact you telephonically and you're able to return in the event of a question, a problem, a verdict in 5-10 minutes. I also mentioned that just as soon as we finish our immediate business, I have another docket that I'm going to be conducting, and of course any time I'm needed in the trial, that docket will be halted and we'll address the trial. So here are the instructions in the verdict form. They can look at that too. The warrants, and then that can give them to them along with the evidence to take back. So at this point, I'll stand in recess awaiting further.
Thank you.
I'll be. Good afternoon. We've got Mansfield here for the state, Mr. Tucker here. Back on the record. Deputy Riccio advised me that one of the jurors informed him that they had some medication in their car that they needed. So I felt it appropriate to convene and present my options or hear from both sides as to their suggestions, but the jurors can't deliberate when any one of them is not present, and obviously they also can't have any exposure to outside influences during deliberations. So I propose one of two things. If, and Deputy Riccio has indicated he's amenable to this, if the juror is agreeable to having the deputy go out to the car and get the medication and deliver it to the juror, that would be the simplest solution, because then the deliberations could proceed, the person would get their medicine, and all is well. If the juror doesn't feel comfortable with that, then basically I would have to bring the jury into the courtroom. I would have to explain that they can't deliberate in the absence of anyone. I would then have to explain to the individual juror that they can go and get their meds as long as they do so expeditiously and not obviously have any contact with any information or anyone about the case. And basically, in an abundance of caution, have them stay right here. We all kind of sit still. That way, there's no question that there's no deliberation going on. And when the person returns, then they go back to deliberating. So those are the two solutions that I see.
Your Honor, if I may offer one on one.
What would
The deputy, could the deputy escort?
Well, you
I'm sorry, could the deputy escort the juror to their car to get the medication, making sure that they're not having contact with anybody?
Yeah, I mean, that could be also,
Judge, I'm fine with either one of the things Your Honor proposed. The state's fine with either one.
I'm fine with any of them. I'm just trying to look for the easiest.
so then, Deputy Riccio, would you go inquire if the juror would object or be to you getting the medication? If that's the case, could you then report back to us before you do it? And if it's not the case, tell us that too.
Yes, sir.
Thank you. And they did offer, have the deputy offer the jurors lunch. And again, it's from a fund that's there at the clerk's office just for these purposes when jurors have to stay together. They did order it. The order's been placed, and I guess it's on the way. Excuse me?
The food is here now.
The food is here. All right. So that way they can stay together, they can have their lunch, and they can continue to deliberate without having to separate. So let's see what the word is here.
Judge, the juror preferred to go get it themselves. Yes.
Okay, so then we'll have to bring in the jury then, and that's what we'll do.
All jurors are present.
Okay, please be seated, members of the jury. Welcome back to the courtroom. Have a seat. Deputy Riccio has explained to me, and I've explained to the state and Mr. Tucker, that one of you, and I'm not going to name names, I don't want to do that, has requested to have the opportunity to get some medication that's in their motor vehicle. And of course, we want to allow any one of you, if there's some medication you need to take, to be able to get it. So I don't want to make a big deal of this, but I want you to understand why I'm using procedures that I'm going to, because jury deliberations, the integrity of those deliberations have to be safeguarded, and we can't have any question about that. So while it may seem, gee, I'm making a big deal of this, if perhaps you understand why, then it will make more sense. Jurors can't deliberate while any one of them, I mean, even the instructions I gave you said if somebody goes to the bathroom, you got to stop. So obviously, if somebody vacates the jury room, then the deliberations have to stop. So what I'm going to propose is that the person be escorted by the deputy, and they've been consulted and they're agreeable to this. Go get the medication. The reason we have the escort is, again, the integrity of the jury deliberations. We can't have even this possibility that somebody would be approach the individual, or there'd be, who knows, some newspaper on the ground that, you know. So to avoid all of that, we're going to have the deputy escort the person quietly, as expeditiously as possible, get the meds, And meanwhile, I'm going to ask you folks to stay right here. They seem a little awkward, but for whatever it takes, 5 minutes, we're all just going to sit here quietly. Why can't we go back in the jury room, Judge? Because of what I told you. It's just clearer and safer if we just stay here, sit quietly. Then we all know there's been no deliberations. We all know that the mission was successful. We all are excused back together and the deliberations can resume. So that's what we're going to do. I'd ask whoever it is, again, I want to name names, just stand up, go with the deputy, and we'll do what I said, and we'll sit quietly in the interim. Okay. So. Okay. I think you can stay right there. So, mission accomplished? Yes. Okay, so the record should reflect that the objective was achieved, that all the jurors remained here in the courtroom other than the one who retrieved the medication under the deputy's escort. There was nothing unusual that occurred, or influences that were involved at all. Okay, we've remained here. There's been no deliberations, so now, thank you. Members of the jury, you can now return to the jury room and resume your deliberations. All right, unless anybody has any input, we took care of that situation.
It's fine, Your Honor.
So they're going to continue with their deliberations, and we'll just stand by when we next hear.
Thank you, sir.
All right. Okay, well, we're all here who need to be here. Defendant and prosecutors, court personnel. I've got a note from the jury. Judge Jones, we have come to the unfortunate conclusion that we are a hung jury and need guidance on how to proceed. Thank you. Foreperson, juror number 3. So, I believe how we proceed is we give the Allen charge, the hung jury instruction. Again, inviting comment from either side, but that's the standard operating procedure when you are advised that the jury's hung.
State would agree on.
To be honest, I don't know the procedure, Your Honor. If you wouldn't mind, check with one of my advisors real quick, just to make sure.
Okay.
I would imagine you're right, Your Honor.
You can check with them, go ahead, but that's how it works. There's a specific instruction when the jury says they can't reach a unanimous decision and are deadlocked. It's called the Allen charge, jury deadlock, 4.1.
Oh, never mind. Do it again. Trying to call myself. Okay. Yeah, I've been advised that, yeah, you can go ahead and go with the Allen charge.
Okay, let me just review it. It's 4.1, jury deadlock. Bring them in, please. No, the Allen charge. That's probably the nature of the case from which it emanated. It's standard jury instruction 4.1, jury deadlock. Can we take? That's all right.
All jurors are present in the courtroom, Your Honor.
Thank you. Please be seated, everyone. Welcome back to the courtroom, members of the jury. Yeah, it's cooling down in here. I heard that it might have been a bit stuffy in the jury room. We have fans there, and I did know a technician was trying to get more AC in there, so if it hasn't cooled down, it should. But meanwhile, I received this communication from your foreperson, and I've shared it with the defendant and with prosecutors. It says, Judge Jones, we have come to the unfortunate conclusion that we are a hung jury and need guidance on how to proceed. Thank you. Signed, your foreperson. Okay. There is an instruction that is given by the judge when this happens. So I'm going to give it to you. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is, as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room. Then, taking turns, tell each of the other jurors about any weakness of your own position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. So with that, you may now retire to continue with your deliberations. Jurors are outside the courtroom. I'll give this note to the clerk. We'll make it part of the record, and we'll stand by and see what happens next.
Thank you, Judge. Thank you.
Please be seated. Okay. We're all here. I got a note from our foreperson. Judge Jones, we cannot come to a unanimous decision as to a verdict. Thank you, foreperson. So that's pretty much it. We gave them the Allen charge. They went back and presumably abided by it. They've been out, and so.
The only thing I would proffer, perhaps if we sent them home and told them we'd bring them back tomorrow to give a one last try. I mean, we put 3 weeks into this trial. They've only been deliberating for less than a full day. Juries have often spent days deliberating. It's almost 5 o'clock. I mean, if Your Honor is inclined to think that way, or if you want to just go ahead and...
Your Honor, if I might.
Yes, sir.
Yeah, I would assume discharge the jury at this point. Let them go home.
Okay.
It has been a long trial already. we asked, Your Honor was worried about their time, and they've been here almost a month.
I'm looking for the right way to express this. To me, it's disappointing that we go through this lengthy process and don't get a result, one way or the other. And there's been a lot of time, money, effort, stress, you name it. Everybody's worked very hard, and it's been almost 3 weeks, and you would hope at the end of that process you would get a result. We haven't. I understand the state's suggestion, but I'm disinclined to do it. I'll just fall back on a couple rationale. First of all, when I've been faced with these situations, and they do come up now and again, I give them the Allen charge. They are unable to reach unanimity. That's pretty much it. And plus, even the charge itself, and I'll go back and read it, says, if, I'll declare a mistrial if you can't reach a unanimous verdict. I think it would be disingenuous and counterproductive and not fair to
Does
tell.
anyone even inquire of them if they feel that maybe a night to everybody to sleep on it, come back tomorrow and reconvene would be beneficial?
Again, Your Honor, I disagree at this point. I mean, again,
It's
looking
all
at
right. I'm not going to do it. I believe me. The last thing I want is a mistrial, but we're there. I told them. The Allen charge says, after you have done that, if you simply cannot reach a verdict, then return to the courtroom, and I will declare this case mistried and will discharge you with my sincere appreciation. So I understand the suggestion, but I'm not going to do that, to say, okay, sleep on it, come on back tomorrow, or how about that? And then, no. Sorry. Certainly understand and pretty well express my sentiments, but I just have not seen that procedure over the length of time I've been a judge and a trial lawyer, and it seems contrary to what the rule says and doesn't say. So, no thank you. Let me find the discharge instruction. Which is, I've got to remember what that number instruction is. 4.2. There it is. Okay. Bring them in.
Alternates, President of Courtroom, Your Honor.
All right, please be seated, everyone. Welcome back, members of the jury. I've received the latest communication, shared it with the defendant and prosecutors. I'll recite it now. Judge Jones, we cannot come to a unanimous decision as to a verdict. Thank you, foreperson. So, you remember the Allen charge I read you when we first were notified of this deadlock, and I told you that if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried. So that's at this point what I'm going to do. If you all can't reach a unanimous verdict, then I accept that fact. I'm going to declare this case a mistrial. So with that, I'm going to give you a final instruction here, ladies and gentlemen. I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. So it's been almost 3 weeks. As I've told you throughout, and I sincerely meant it every time, and I mean it now. You've been a great group of people. You've been very flexible. You've been very understanding. You've been very patient. You've been very attentive. And obviously, you gave it your best consideration. We can ask nothing more than that. So thank you. I will say this also about this case has received substantial media coverage, and I'm confident that you all have insulated yourself from that as I have asked you to do. I have no doubt that you followed my cautionary instructions to the letter, and I thank you for that. But meanwhile, there's been certainly a lot of coverage. You see the TV cameras have covered this on Court TV. I believe there's a YouTube channel that's covered it as well as the print media. So as I said in this particular instruction, now it's up to you to decide whether to protect your privacy as a juror. There may be requests from many different sources, and you will make that decision as to how you want to handle that. You're no longer under that order that I gave you about not talking to anybody about the case. It'll be up to you. So with that, thank you so much, folks. You're now discharged as a jury in this case. So you can go with the deputies, get your stuff, and take care. Yeah, we're going to make this no part of the record. Okay, the jurors are gone. Be at ease. So, here we are. Almost back to square one. But in any event, what we need to do is put this case back on a docket. So the question is when? I don't think February 8th makes a whole lot of sense.
No, let's go with the March one.
So we've got March 7th pre-trial.
Yes, sir. Judge, we would just ask for the court to reinstate the gag order. There's been so much out there that when we retry this case, we're still going to have to get a jury from this community to the extent that we can limit now the information that's getting out there. I know that you know it's absurd how much attention this case has gotten, but we are going to have to pick a jury again from this community. So I'd ask this court to reinstate the gag order in order to assist us in the endeavor of doing that in a couple of months.
Well, one step at a time, so I will certainly consider that request. So March 7th for the defense?
March 7th, yes.
Okay.
Well, what time do we want? Is he still 1:30, 9? We'll be calling it at 9, even though it's first say.
Well, 9 o'clock is, that, usually the 9 o'clock call is for cases with private attorneys. PD and pro se is usually at 1:30. So I don't know why we should necessarily break from what we've been doing, but if,
9 a.m.?
unless there's any,
9 a.m. works.
all right. So 9 a.m.?
9 a.m. March 7th, correct?
Yeah.
Yeah, we'll give him his notice.
Okay, that's one thing. Next thing, so the conditions of your release remain the same, and we're going to go back to the random, whatever the testing regimen was,
Yes,
in
sir.
terms of whatever substance or alcohol. That's,
Yeah.
you know, I basically during the trial had slacked off on that, feeling that again you were here constantly, you were busy with your defense, and so, but now all the conditions of the release remain in effect.
Okay.
So as far as the protective order or the so-called gag order, does the defense have any position as to that?
Your Honor, I would be of the opinion that it's, look, we vacated the gag order because it became pointless, and I still think it's pointless at this point. Like, again, yes, there has been plenty of media coverage, and I don't see how we're going to roll back and unring the bell at this point. You know, so I don't see the point at this point. I just don't see the point.
Yeah, I mean, I got to tell you, that seems to me to be something that's going to take some thought. So I've got to refresh my recollection as to the extent of that and what that would mean. So that means that,
Right, Judge, we were not allowed to talk about the case to the media, you know, in interviews about, I mean, the defendant was posting on Facebook all day today, even during closing arguments. So, I mean, how are we ever going to get a jury here in 2 months that hasn't heard something about this case and is tainting this jury pool?
Your Honor, if I might, I somehow doubt the rule.
let's relax. Not everybody just relax, okay? Let's just. I know it's been a long 3 weeks, but now's not the time to get too argumentative. I got to think about this. I understand the impetus, but and the rationale. I'm just asking myself the practicality of it and the enforcement of it, and you know, I need a little time to think about it.
I understand, Judge. Let me just put on the record, last night I received about 11 threats on my phone, on my personal cell phone. They started yesterday afternoon, they continued into the evening. I don't know how my cell phone number got out there. I suspect how it got out there, but now I'm receiving death threats to the point where I'm going to have to change my phone number. This is what I'm talking about. This kind of media blitz is affecting me personally, and I don't think it's right. So I'll be changing my phone number because somehow my phone number has been compromised, and I got threats against myself and my family. So,
Mr. Tucker, please, just
Hold on, not Mr. Tucker.
let me just. Mr. Mansfield has just raised a legitimate concern. I'll give you the chance to respond. So that's very troubling. I certainly am disturbed by that fact. I've received in my office, which I've endeavored not to read the emails or ask my assistant not to, to tell me what these phone calls are about. I'm not aware of any threats, but I'm certainly aware of people's criticisms and comments and opinions. That's a natural product of the coverage this case has received, and so all I'm asking myself, and I'll confess, I don't know that I have my head wrapped around the issue right now. I remember the order that I issued. I reviewed it at the beginning of the case when I suspended it, and it was pretty involved. And I would think I'm almost inviting problems if all of a sudden I say, oh, it's in effect, and all these people are curious and the like start talking and asking questions, and I don't want to have anybody in a gotcha situation. So certainly I think rules and ethics and laws would certainly say that there should be no communicating threats, no intentional rabble-rousing, so to speak. I don't know what, or directing animosities or hostilities or anything toward anybody in this case. And I'm certainly not going to be pinpointing or blaming anybody. So I don't know what more I can say than that. I don't know, Mr. Tucker, now you wanted to say something?
Actually, I didn't say anything earlier, Your Honor, but I would like to say this. Look, I receive, I don't know how much hate mail myself, right?
Okay.
And I do, don't get me wrong, I do take offense at the, was it the innuendo that somehow, I had something to do with Mr.
Never said
Mansfield.
that.
No, I don't think.
I think it was an innuendo, though.
Well, I didn't construe it as such, but there's no.
Anyway, I have no control over those people, what they do, and I somehow doubt the whole world looks at my Facebook. So anyway, thing is, Your Honor, like I said, I think I'm still of the opinion that we vacated it for a reason. Same reason I would say that it's probably not a good idea to reinstate. But I'm deferring to the court at this point because you say you need time. I'm more than willing to let you have time.
Okay.
Decide as you may.
Well, in any event.
Judge, may I add one final point with your permission?
Okay, go ahead.
Just very briefly, Judge, whether you lift or vacate the order or reinstate it, you did ask us, once you vacated it, to act professionally amongst each other. And I can tell the court that the state has been called dirty bastards, you've been berated, and we have not once made a comment about the defendant in this case. So we should at least have that level of ethics amongst us and not have to face that on a day-by-day basis.
Okay. I don't think Mr. Mansfield indicated, I certainly didn't construe it as somehow or other you encouraging or being the source of these threats. But there's no doubt, Mr. Tucker, that you have endeavored over the course of this to make this a public affair with all your social medias and all your other efforts to publicize it. That's coming from your side of things. That's just a fact.
No, that is a factor. I'm not going to deny.
So to the extent that, unfortunately, there's folk in this world, this country, that they get riled up about certain things and act inappropriately. I know that's a very general statement, but it's an offshoot. So I do agree with Mr. Alvarez. I did say that, and I think mutual respect is what I would expect. And if I need to have some, or if there needs to be some evidentiary hearing or some showing when there's a renewed motion to reinstate the protective order, I'll be happy to do it. I'm just saying right now at this point in time for me to just put my foot down and say, oh, it's back again. I understand the request, but please understand my belief that I need to look at it with a clear head.
Your Honor, I'm just to reaffirm or reassure you. Yes, I can go ahead and tone my language down. I can definitely do that. Again, if mutual respect is what you're looking for, I have, as you saw this morning, I do have some ethical concerns myself, but at the same time, I can at least keep my public persona, as far as what I say, respectful.
Thank you. So I think that's pretty much it for now.
So Thank you, Your Honor.
Appreciate everybody's hard work. I'm just going to sign this order here as to the